People versus Brandon Martin, RAF 150-6112. Record should reflect Mr. Martin as present in both counsel. People are present and all members of our jury and alternates are present. Good morning, ladies and gentlemen.
Good morning.
Welcome back. We are ready to get started this morning. A couple of things before we get started. First off, I have a new witness list to read to you. These will be the names of the potential witnesses for the penalty phase. If any of these names ring a bell to you, please take note of it, and I will ask you when I'm done whether or not you know any of these people. So we do need to know that at the outset. Secondly, I have a new set of instructions, preliminary instructions to read to you. There will be additional instructions as we go through this phase of the trial and at the conclusion of the trial. So I will be reading some instructions to you this morning. And then when I'm done, we'll hear opening statements once again, because this is a different phase of the trial. You'll hear from the prosecution and the defense in their openings. Then we'll go right into evidence. Now, the witness list is rather lengthy, but I think you will see that the witnesses will be rather short in their testimony for the most part. But in any event, not all of these witnesses may necessarily testify to. These are all of the potential witnesses that might be testifying during this phase of the trial. All right, so the following are civilian witnesses who are potential witnesses. Leslie Harvey, Michael Harvey, Jeremy Swanson, Josh Swanson, Robin Lancaster, Diane Johnson, Michael Anderson, Miles Odell, Sean Martin, Emily Duran, Jamal Abdullah, Eddie Rosario, Gabrielle Maciel, Matthew Budgell, and that's spelled B-U-D-G-E-L-L, Alan Abrams, and Melody Martin. Then we have Dr. Suter, Dr. Robert Suter, Dr. Jennifer Bosch, Dr. Robert Solomon, Dr. Peter Lowe, and Dr. Vasilika Valku, L-V-L-C. Any of our jurors seated in the jury box think that recognize the names of any of those potential witnesses? All right, how about on the right side of the room, any of the rest of our jurors and our alternates, any of you recognize them? All right. And ladies and gentlemen, I do have some preliminary instructions, as I mentioned, and then we will begin with openings. This phase of the trial is to determine the defendant's penalty. The law provides for two possible penalties: death or life in prison without the possibility of parole. You must decide which penalty the defendant will receive. At the end of this phase of the trial, I will give you a set of instructions that apply to this phase of the trial. Some of these instructions will be the same or similar to the instructions you have heard before. However, you must follow only this new set of instructions in this phase of the trial. The first step of the process is for opening statements. Next, the people will offer their evidence. Evidence usually includes witnesses' testimony and exhibits. After the people's case, the defense will also present evidence. After you've heard all of the evidence and before the attorneys give their final arguments, I will instruct you on the law that applies in the case. After you've heard the arguments and instructions, you will go to the jury room to deliberate. I will now instruct you on the law that applies in this phase of the case. I will give you a copy of the instructions to use in the jury room. You must decide whether the defendant will be sentenced to death or life imprisonment without the possibility of parole. It is up to you and you alone to decide what the penalty will be. In reaching your decision, consider all of the evidence from the entire trial, unless I specifically instruct you not to consider something from the earlier phase. Do not allow bias, prejudice, or public opinion to influence your opinion in any way. You must follow the law as I explain it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions. Pay careful attention to all of these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in ordinary use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary everyday meanings. Some of these instructions may not apply depending on your findings of the facts of the case. Do not assume just because I give a particular instruction that I am suggesting anything about the facts. After you've decided what the facts are, follow the instructions that do apply to the facts as you find them. In reaching your decision, you must consider and weigh the aggravating and mitigating circumstances or factors that are shown by the evidence. An aggravating circumstance or factor is any fact, condition, or event relating to the commission of a crime above and beyond the elements of the crime itself that increases the wrongfulness of the defendant's conduct, the enormity of the offense, or the harmful impact of the crime. An aggravating circumstance may support a decision to impose the death penalty. A mitigating circumstance or factor is any fact, condition, or event that makes the death penalty less appropriate as a punishment, even though it does not legally justify or excuse the crime. A mitigating circumstance is something that reduces the defendant's blameworthiness or otherwise supports a less severe punishment. A mitigating circumstance may support a decision not to impose the death penalty. Under the law, you must consider, weigh, and be guided by specific factors, where applicable, some of which that may be aggravating and some of which that may be mitigating. I will read you the entire list of these factors. Some of them may not apply in this case. If you find there is no evidence of a factor, then you should disregard that factor. Factors are as follows. A, the circumstances of the crimes of which the defendant was convicted in this case, and any special circumstances that were found true. B, whether or not the defendant has engaged in violent criminal activity other than the crimes of which the defendant was convicted in this case. Violent criminal activity is criminal activity involving the unlawful use, attempt to use, or direct or implied threat to use force or violence against a person. The other violent criminal activity alleged in this case will be described in these instructions. C, whether or not the defendant has been convicted of any prior felony other than the crimes of which the defendant was convicted in this case. D, whether the defendant was under the influence of extreme mental or emotional disturbance when he committed the crimes of which he was convicted in this case. E, whether the victim participated in the defendant's homicidal conduct or consented to the homicidal act. F, whether the defendant reasonably believed the circumstances morally justified or extenuated this conduct in committing the crimes of which he was convicted in this case. G, whether at the time of the murder the defendant acted under extreme duress or under the substantial domination of another person. H, whether at the time of the offense the defendant's capacity to appreciate the criminality of his conduct or to follow the requirements of the law was impaired as a result of a mental disease, defect, or intoxication. I, the defendant's age at the time of the crimes of which he was convicted in this case. J, whether the defendant was an accomplice to the murder and his participation in the murder was relatively minor. And K, any other circumstance, whether related to these charges or not, that lessens the gravity of the crime, even though the circumstances is not a legal excuse or justification. These circumstances include sympathy or compassion for the defendant or anything you would consider to be a mitigating factor, regardless of whether it is one of the factors I have listed above. Do not consider the absence of a mitigating factor as an aggravating factor. You may not consider as an aggravating factor anything other than the factors contained in the list that you conclude are aggravating factors in this case. You must not take into account any other facts or circumstances as a basis for imposing the death penalty. Even if a fact is both a special circumstance and also a circumstance of the crime, you may consider that fact only once as an aggravating factor in your weighing process. Do not double count that fact simply because it is both a special circumstance and a circumstance of the crime. Although you may consider sympathy or compassion for the defendant, you may not let sympathy for the defendant's family influence your decision. However, you may consider evidence about the impact the defendant's execution would have on his family if that evidence demonstrates some positive quality of the defendant's background or character. You have the sole responsibility to decide which penalty the defendant will receive. You must consider the arguments of counsel and all of the evidence presented during both of the phases of this trial. In reaching your decision, you must consider, take into account, and be guided by the aggravating and mitigating circumstances. Each of you is free to assign whatever moral or sympathetic value you find appropriate to each individual factor and to all of them together. Not simply count the number of aggravating and mitigating factors and decide based on the higher number alone. Consider the relative or combined weight of the factors and evaluate them in terms of their relative convincing force on the question of punishment. Each of you must decide for yourself whether aggravating or mitigating factors exist. You not all need to agree whether such factors exist. If any juror individually concludes that a factor exists, that juror may give that factor whatever weight he or she believes is appropriate. Determine which penalty is appropriate and justified by considering all of the evidence in the case, the totality of the aggravating and mitigating circumstances. Even without mitigating circumstances, you may decide that the aggravating circumstances are not substantial enough to warrant death. To return a judgment of death, each of you must be persuaded that the aggravating circumstances both outweigh the mitigating circumstances and are also so substantial in comparison to the mitigating circumstances that a sentence of death is appropriate and justified. In making your decision about penalty, you must assume that the penalty you impose, death or life without the possibility of parole, will be carried out. To return a verdict of either death or life without the possibility of parole, all 12 of you must agree to that verdict. All right, ladies and gentlemen, those are the initial instructions. You will receive additional instructions at the conclusion of this trial. At this time, I will be turning the floor over to the lawyers. Remember, once again, their statements are to be considered by you for the purpose of what it is that they have to say about the case. But remember, the evidence that you must base your decision on will come from the witness stand.